So we just got done shooting the last of our Rethink Retirement series. We talked about legacy planning, and there is a ton to unpack there. There's so much detail. I wanted to focus on three distinct things from that show. One is about probate. A lot of times when we talk about probate, we make it kind of feel like it's this bad thing. It is not. It is the legal process that you go through to make sure that what you want to have happen to your estate once you pass away actually takes place. So that by itself is a really good thing. The bad part about probate is just the cost. And if we think about the cost, if you develop a will and anything that transitions through the will goes through the probate, let's say you have $1 million estate. We talked about a 3% cost. That's $30,000 potentially that your estate could lose, could pay in those fees if you go through probate. That is the big disadvantage. Plus the public stuff and all the other stuff we talked about. But from a cost standpoint, if a trust costs you, let's just call it $3,000, $3,000 to set up, saves the estate $30,000 on the backside. So you can see this is why when we talk to the families and individuals we serve, we want them to know how these different things work. And then they can decide, you can decide once you know, okay, do you need a will? This is what would happen if you have a will. Do you need a trust? This is what would happen if you need a trust. And once you know the good and the bad of all of those, you can make a decision that is right for you. Because just because your neighbor or your siblings have a will or have a trust doesn't mean that that is going to be right for you. Because your retirement, your assets, everything about your retirement is unique to you. The other key takeaway is when you set up your legacy plan, this is one of the big overlooked mistakes. When you set up your legacy plan, make sure you use it. What I mean by that is if you go through the work and the cost of setting up a trust, make sure you fund the trust. So many times, and a lot of good estate planning attorneys will caution you on this. People will go through the expense, they'll pay their $3,000, they'll go through all the questioning with the attorney, they'll set the trust up, and then they don't do anything with it. They forget to fund it, and then it is useless. So a lot of people will own a house, a primary residence. What you do is you retitle the name of that house ownership to the trust. Now, in a lot of states, this can be different. In the state of Iowa, you cannot put a payable on death designation on your house. It's just not allowed in the state of Iowa. Other states you can. So one of the most effective ways to have your house bypass probate is to retitle it into the name of a trust, and then that asset should bypass probate as well. So you create the trust, retitle your house into the trust, refer to the attorney on what you want to do with your vehicles. Sometimes they'll tell you, based on a lot of different factors, whether or not you want to title your vehicles in the name of the trust. But many attorneys will say, let's leave the vehicles out and let's do the house. The other thing you can do is any life insurance or any IRAs or any 401k plans, you can use the trust, but you want to be very careful of how you use the trust with these different vehicles. Almost every case, you do not want the trust to own those different investments, but you may want them to be a beneficiary. Also, in many cases, you won't want it to be a primary beneficiary. You'll want it more to be a contingent beneficiary. But again, there's so much that goes into when you would want to, when you wouldn't want to. Refer to your estate planning attorney to make sure that you're doing it right for you. When you do hire an attorney, make sure that that attorney specializes in estate planning. Attorneys can do a lot of things, and if you look at their websites, there's going to be a whole list of different things that they say they do. You want to make sure that the one that you hire for your trust, your will, your estate plan, specializes in estate planning and specializes in estate planning in the state that you reside. One last thought on the legacy piece is there is a misconception that if you set up a living revocable trust, that's going to help protect assets in the event that you need long-term care. There are trusts that you can set up to protect against the assets being used for long-term care, but a living revocable will in most cases won't get that done. So if one of your primary motives in your estate plan is to protect against long-term care expenses, make sure you voice that to your attorney, to your retirement planner, and then they together can make sure that they come up with the most effective plan for you, because the will The last will is not going to do that for you. Also, in most cases, the living revocable trust will not do that for you as well. So for more information, you can check out the show. If you have any questions about your legacy plan or your retirement plan, you can go to retirereadycall.com and you can schedule a Retire Ready call with a retirement planner to help you on your way creating your most effective retirement plan.